These are Benjamin Cardozo's methods of judicial processes. The first one is going to be the method of philosophy. The method of philosophy deals with the Constitution and statute. So when the Constitution and the statute are clear, the role of the judge becomes secondary. But when there are gaps in the law and the Constitution and the statute are not clear or fail, this is when the judge's interpretation is needed. Cardozo states that nothing is stable, nothing is absolute, and all is fluid and changeable. The method of philosophy deals with logical and orderly succession and development in the law, and the judge must first extract the underlying principle and then determine the path or direction along which the principle is to move or develop. And it's used when strictly logical or unbending applications of a principle of a law have worked a grave injustice. And it's not supposed to be used when its method and ends are treated as supreme and final. And another goal of this method is to recognize the need for human positive law that grows with time. Next is going to be the methods of history and tradition.
Cardozo's methods of history is pretty well straight to the point. It is the investigation of the origins of the law and why they were put into place in the first place. It's to clarify the issue rather than to solve it like the other methods.
The method of tradition is defined as a principle of selection to guide the judge in determining the application of a principle of the law. And there are two others that came before Cardozo. Koch's theory was that common law separated from tradition, and Blackstone's theory was that tradition pervades all of the law. Cardozo has a totally moderate view of tradition, which is opposite of the two who came before him. He states, at all events, we look to customs not so much for the creation of new rules, but for the tests and standards that are to determine how established rules shall be established. And up next is the method of sociology.
The method of sociology is based off the welfare of society and the commonwealth of the people. Its goal is to search for social justice, and one must not look to the individual for a reason or by the rule, or they should search for social welfare for the common good. Sociology demands that a judge must make a decision within his narrow bounds for social justice.
Roe versus Wade was a 7-2 majority opinion ruled court case, and Blackmun gave the majority opinion in the case. It was concerned over a woman's choice whether to have an abortion is protected by her right to privacy, and they ended up determining that a woman's right to decide involved the question of whether the Constitution protected her right to privacy. The 14th Amendment of the Constitution prohibits states from depriving any person of liberty without due process of law, and it does protect the fundamental right to privacy of the woman. The word person did not apply to a fetus, so therefore a woman's right to choose fell within the right to privacy that was protected by the Constitution. The method that was applied in this case was philosophy, and the reasoning was because part of the method of philosophy is that it is concerned about what the Constitution says or fails to say when it comes to the law. In the reasoning for the majority opinion, they examined the 14th Amendment of the Constitution and what it protects. They did not need to discuss it further and fill in gaps since the Constitution laid it out for them.
In Bowers v. Hardwick, there was a 5-4 ruling, and Blackmun gave his dissenting opinion. It upheld the Georgia state law criminalizing oral sex and anal sex in private between consulting adults. In this case, it was in respect to homosexuality sodomy because it was between two men. He said that there was obviously focused on homosexual activity and refusal to consider our right to privacy.
The method that we applied was again philosophy, and the reasoning behind this was because it was concerned with the 14th Amendment right to privacy, just like Roe versus Wade was. And we determined that sociology is the method that he cast aside in this case. And the reasoning was because it did not concern the welfare of society when these individuals were in their home committing these acts, and they were in private and not disrupting anyone.
In the Obergefell v. Hodges case, it was a 5-4 decision which ruled that same-sex marriage is a right that is guaranteed by the Due Process Clause and by equal protection, which also falls under the 14th Amendment. It requires all states to issue marriage licenses to same-sex couples who are seeking one, saying that banning marriage to same-sex couples is unconstitutional. The two methods that applied to this were philosophy and sociology. Because of philosophy, there's a need for the human positive growth with time. It was evident in this case, and for the sociological, it affects a certain group of people that has gotten larger over time, and because of that, it's best for society to put forth this law. History and tradition can be applied to all the cases. The methods of history can be applied to the 3 court cases because simply it applies to the origin of the law. The method of tradition can also be applied because tradition is actually looking back on other laws and then saying, because of past decisions, we're going to make this law.
In Schenck versus U.S., Schenck mailed thousands of pamphlets to men who were drafted into the armed forces. And in these pamphlets, he said that the government had no right to draft them and send them to other countries to kill people. And then the government accused Schenck of violating the Espionage Act, and it said that Schenck's pamphlets were intended to weaken the loyalty of soldiers and to obstruct military recruitment. Schenck answered back saying that the Espionage Act was unconstitutional and it broke the First Amendment. Justice Holmes said that in many places and in ordinary times, Schenck would have the right to say everything that he said in his pamphlets. However, since it was at the time of war, that a person's freedom of speech extends and depends on the circumstances. Holmes says during a war, the government certainly has the power to prevent obstructions to recruitment, and therefore has the power to punish someone who uses words that are proven to cause such obstructions.
In Debs versus U.S., on June 16, 1918, Eugene V. Debs, a leader of the Socialist Party of America, gave a speech in Canton, Ohio, protesting involvement in World War I. During the speech, he discussed the rise of socialism and specifically praised individuals who had refused to serve in the military and obstructed military recruiting. For his speech, he was arrested and charged with violating the Espionage Act. At trial, Debs argued that the act violated his right to free speech under the First Amendment. A federal district court rejected his claim and sentenced him to 10 years in prison. The conclusion was a unanimous opinion authored by Justice Oliver Wendell Holmes. The court found that Debs' case was clearly similar to Schenck versus United States. In Schenck, the court had concluded that the arrest of an individual for distributing leaflets encouraging readers to oppose the draft was constitutional. The court found Debs' sympathy for individuals convicted of opposing the draft and obstructing recruitment similar to the situation in Schenck. Thus, Debs' conviction was upheld. In Gitlow versus New York, Gitlow was a socialist who was arrested for distributing copies of a left-wing manifesto that called for the establishment of socialism through strikes and class action of any form. He was convicted under a state criminal anarchy law which punished advocating the overthrow of the government by force. At his trial, he argued that since there was no resulting action flowing from the manifesto's publication, the statute penalized utterances without propensity to incitement of concrete action. The New York courts had decided that anyone who advocated the doctrine of violent revolution violated the law. In conclusion, it was a 7-2 decision that Gitlow was not protected under the First Amendment, although by virtue of the liberty protected by due process that no state shall deny the 14th Amendment. On the merits, a state may forbid both speech and publication if they have a tendency to result in action dangerous to public security, even though such utterances create no clear and present danger.
All 3 of these cases are related by something called the dangerous tendency test. This test may decide that an entire class of speech is so dangerous that it should be prohibited. These decisions can be upheld if they're not unreasonable, and the defendant will be punished even if their speech created no danger at all. The question in every case is whether the words are used in such a circumstance and are of such a nature as to create a clear and present danger that they will bring about the evils that Congress has a right to prevent.